Just as in England and Wales, a purchase of a property in France is completed over 2 stages: signature of the initial sale contract and then the final sale deed. The sale deed itself must be completed by a notaire practicing in France, and all of the documentation is going to be in French. There are occasionally translations, but they are not necessarily up-to-date translations of that particular contract, but could be translations of a previous version of a document. So we will only ever work on the original French version of the documents to make sure everything is in order for our clients. Once a contract is signed, there's a 10-day cooling off period in favour of the buyer, and so a buyer can withdraw for up to 10 days after signature of the contract without necessarily giving any reason for doing so, and they are fully entitled to the reimbursement of their deposit if they paid it by that point. The seller does not have a similar right to withdraw from the transaction, and so the seller is actually bound into a sale as soon as they've actually agreed the price with the buyer. Once the first contract has been signed, the notaire will be addressing a number of conditions to make sure that these are all satisfied. That will normally take at least 2 months, and so the completion is usually going to take place at least 2 months after the original sale contract has been signed. It is usually preferable to attend the notaire's office for the final completion meeting, as this will usually be an amicable event with the sellers and the buyers all in attendance, and an agent in attendance as well. So everyone will go through the whole document, the whole sale deed. It will also offer the buyers the opportunity to visit the property just before completion to make sure everything's still in order with the property. If one of the parties is not able to attend, they can be represented at that final completion meeting by execution of a power of attorney. But if they are going to complete by power of attorney, they should be planning this at least a month in advance of the due completion, because it will usually require legalisation, and that process itself can take several weeks. The first thing a seller needs to do when they're putting the property on the market is to obtain a set of pre-contract diagnostic inspection reports. These reveal the state of the property in a set of given areas, such as whether there's any termites, whether there's any asbestos, whether there's any lead-based paint, and other issues. Those reports need to be carried out before the property can be even put on the market, such that when a buyer is looking to make an offer, they should be able to see those reports and understand exactly what it is they're buying. In practice, buyers will see those at the time they come to see the first contract. The seller also needs to produce a good title to the property so that they can establish that there are no third-party rights affecting the property that may impact upon the buyer's right of ownership. In fact, the notaire will produce a title history traced back over at least 30 years, from which it can be established that there are no other rights that can be greater than the buyer's. The seller will need to make a number of declarations in the sale contract. For example, that there's no ongoing litigation in relation to the property, that there are no encroachment issues along with neighbouring land, that the seller's fully up to date with all of their tax obligations, and that there are no other known problems with the property. The seller also has an obligation under what's known as vice caché, which is hidden vices, in which if a seller has knowledge of something that they don't disclose to the buyer and actually hide from the buyer, then the buyer may be able to have the whole sale contract set aside, and if they completed the purchase, then the whole of the purchase price refunded to them. An example of which would be if the seller is aware of, for example, damp rot in the property that they've hidden from the buyers whenever the buyer's inspected, and as such that the property was substantially damaged because of that. If the house in France that you're selling is not your main residence, then you may be liable to pay French capital gains tax. If you're UK tax resident, then you may also be liable to pay UK CGT. There's a double tax treaty in place that means that you don't pay the same tax twice, although you do end up paying the greater of the two taxes, such that if the UK CGT liability were greater than the French liability, then you would end up paying the difference to the UK tax. The French CGT can be reduced by a number of methods. You're allowed to take into account the cost of notaires fees and agency commission and other legal professional charges. You're allowed to take into account the cost of any works that have been carried out to the property, provided those works were carried out by registered French artisans, and not therefore by DIY or done by a friend of yours who's a British builder but not registered in France. If you are going to offset the cost of any works that you've carried out to the property, you must be meticulous in ensuring that all of your written estimates, all of your invoices and all proofs of payment are kept scrupulously. You have to produce all of that evidence to prove that the work was carried out properly and was paid for properly and was actually paid for by you and not by somebody else. If you own the property through a French SCI company, then any works that you might have carried out to it must have been carried out in the name of that company and not in your sole names. French capital gains tax is indexed, reduced down over 22 years, such that if you own the property for more than 22 years, there is no CGT payable. There might, however, be a contribution to social charges that's still due, because that is payable for up to 30 years after the purchase of the property. If you're a UK tax resident, then you may need to employ a fiscal guarantor if the sale of the property is for more than €150,000. That guarantor stands in your place to represent you in the event that the French tax authorities decide that not enough tax was paid, and that guarantor would be liable to pay any surplus tax on your behalf for a period of up to 5 years after completion of the sale.